Do you know if my clerk's office is satisfied with what you provide?
We provided the documentation to Ms. Clark, and I believe she was satisfied with that.
All right. I will, I'm gonna just give you a window of time just in case. But I will reflect that the file is closed and she is discharged as part of my proposed order language here as requested. Well, I guess if I do that, they'll probably come after me looking for edits on that. I'll tell you what, if there's an issue with it, I'm sure they'll bring it to you.
Thank you.
Well, first I want to say I'm very sorry for your loss.
Thank you.
There is a waiver in the file from Mr. McFarland, who has also indicated he's examined that accounting and the final partial accounting as referenced by Mr. Hartung. The file does contain proof of service on that proposed accounting, as well as the completion of all of the other obligations. So I will sign the order allowing the account, the 34th, and the final accounting, including fees and costs, and acknowledging the transfer of assets, discharging you from your fiduciary duties as a conservator, and closing this file. As it relates to the probate file, Mr. Hart.
Your Honor, we set this up for hearing today on a couple of different matters. First, to ask the court to determine the legal heirs, as well as appoint Ms. Salinas as personal representative for her brother's estate. But in a kind of a very unique situation, at least to me anyway, we have a will before the court that is completely unsigned. They were not able to locate the original will. They were not able to locate a copy of the original will. But Terry Trott, who is a longtime attorney in Lenawee County, and especially in the Hudson area, and Marcia Whitehouse, thank you, who is the wife of Jim Whitehouse and also a longtime attorney in that area, now lives in Albion, I believe lives in Albion.
Yes.
Have signed affidavits confirming that they witnessed and saw the execution of that will. And we're asking the court to consider approving that will and admitting it into probate. In this particular matter, mailings have gone out properly. We've also had a fairly thorough publication of this issue that appeared in the newspaper or online, however they're doing it these days over there. And again, that's what we're aiming to accomplish today, is get Ms. Salinas appointed, have the will admitted, and have the court determine legal heirs.
Have you received any indications that there would be an objection to your proposed will?
No, not at all.
Nor has the court, but that's a question I like to cover. That's also why we ask you to publish, to make sure that if there are any issues, that we can understand them and deal with them as quickly as possible. All right, are you ready for me to make the findings?
Yes, thank you.
Very good. The court finds all interested parties were given an opportunity to understand the issues that were raised here today as part of the request to open the estate for probate. The file supports the findings necessary to allow that. There is information in the file indicating that Mr. Gating was a resident of Lenawee County, passing away, unfortunately, December 12th, 2023. The determination of heirs is also uncontested and it appears to be correct. I will allow and enter the will for purposes of directing the probate of the estate as requested. I do find that the supporting information around the production of the document is sufficient to allow that to be the will that directs the administration, as well as the presentation today, and the lack of any objections to that directing the process. So I will admit that will as well and appoint Ms. Janice Salinas as the personal representative. It does not appear supervised administration is necessary at this time, nor that any bond be placed. So the order reflects the petition is granted, the will is admitted, Ms. Salinas is appointed personal representative to serve without bond, and that the heirs are determined as indicated in the order. Sign that. Well. And there should be some letters of authority in here, allowing you to accomplish the goals that you need to. There they are. All right, those are signed as well. Once again, I'm sorry for your loss, but that's all I need from you today. Good luck moving forward.
Thank you, Your Honor.
Thank you, Your Honor.
Take care.
This is the matter of the estate of Dorothy Delker, file 53095.
The court's been asked to open an estate in this matter as well. May I have the names of our participants?
Yes, Your Honor. Attorney Nancy Eaton Gordon appearing on behalf of petitioner John Tuckerman, who sits to my right. If I may, one matter of housekeeping before we begin. My client's a little hard of hearing, and he was wondering if he could speak up. We were having a little he was having a little difficulty hearing in the back. I'm sure it won't be an issue, but I wanted to let you know.
Thank you. No, I appreciate you letting me know, and I will make sure I speak up.
Thank you.
So as Your Honor knows, this is the date and time set for the hearing to open the estate of Dorothy Delker. We do have a will in this case. We are asking that that will be admitted, and also a determination of Ms. Delker's heirs. Ms. Delker passed away as a resident of Lenawee County late last year. And we are going forward with, we had gone forward with attempting to locate her heirs, as she did not have any spouse, children of her own. Her only sibling had passed at a very young age, so we had to do some homework to track down the heirs. We did locate very quickly so individuals who thought they were direct cousins, and it turns out from research we found that they're probably more a secondary relationship as a step or a half cousin. We did notify all of them directly through mailing regardless. We did publish against any unknown or unascertained heirs. We did notify the charities also who are named in the will. We have not received any objections to Mr. Tuckerman's appointment or to the will. We also did receive contact from 2 of the charities, one of which is updating their address for us to where we're supposed to send mail. So we'll update with that with the court as we go forward. We're just asking that the will be admitted and that we have a determination of the heirs so we can move forward with the estate, which under Ms. Delker's very clear instructions were to be distributed to charities that she found near and dear to her within the locality of Adrian and Lenawee County, and also a couple that were special to the state of Michigan. So we would ask for admission of the will and for the probate to be open with a determination of heirs.
Thank you. I see that. Yes. What are the assets that are to be distributed?
We do have a piece of real property. John, what is the address of her house? Sorry.
41, I think it's 415 Tipton Woods Drive.
Thank you. Sorry, I promised him I wouldn't put him on the spot, and I turned around and did that. There's also some investment accounts and bank accounts. The investments accounts are held with Merrill Lynch, I think Edward Jones, a couple other localities, and we have made contact with her local agent on those.
Anything else before I make my findings?
No, Your Honor, we don't have a definitive handle on all of the assets at this time. We do have tax records and things like that that we're going to backtrack to make sure we account for everything.
Good. The court finds all interested parties were given notice for purposes of today's hearing on the request for formal proceedings in this estate. That does.
But here's the surprising part. After reviewing extensive searches, mailed notices, and newspaper publication, the judge finds no valid objections.
Include the publication and the notices to all the interested parties named in the will as articulated by Ms. Eaton Gordon. The file further provides information such that the court finds reliably that Ms. Delker was a resident of Lenawee County. She did pass away on October 13th, 2023, a resident of Lenawee County, making venue proper in this court. I do rely further on the diligent searches of the attorney to determine that there are no known direct heirs at law. It does appear with sufficient support also that Ms. Delker's will does exist, is valid, and should direct the administration of the estate. Mr. Tuckerman is suitable for the appointment, and supervised administration does not appear to be necessary at this time. It is the order of the court, the petition requesting the estate be opened is granted. The will direct the administration of the estate and is admitted to probate. Mr. Tuckerman is appointed the personal representative to serve without bond. and the determination of heirs is recognized by this court in today's order, which I have just signed. I am also signing to admit the will into probate to direct the administration of the estate. And the letters of authority giving Mr. Tuckerman what he needs to accomplish the goals of the will. I'm sorry for your loss.
Thank you.
Unless there's any questions, that's all for today.
No, there's no questions. I would just say that Dorothy was a very dear woman, and even though she didn't have family, she had a lot of friends who did look out for her, including Mr. Tuckerman. So I'm glad to have him here to help carry out her final wishes.
My mom and Dorothy grew up together.
They've known each other for a very long time, so
That's wonderful.
good to have people.
All right, well, thank you very much. That's all for today.
Thank you.
You're welcome.
Good job.
All right. And the Hollis matter.
This is in the matter of Dawn Hollis, file 52202.
All right, we've been here a couple of times on this one, trying to assist and secure the conservatorship by law. And I appreciate Ms. Meinhardt coming on board, and I look forward to the updates on this to see if we can't put this thing to bed, frankly. Interested and participating parties.
Michael McFarland, attorney, guardian at Leitrim.
Your name for the record, sir?
William Dempsey Hollis.
Thank you.
Sarah Meinhardt, I was the special fiduciary for the conservatorship.
Thank you. Ms. Meinhardt, let's go to you first. What is your take on the matter now that you've had a chance to look it over?
Thank you, Your Honor. There was one account listed on the inventory Mr. Hollis filed. Within that account, there was like a $33 deposit once a month. Mr. Hollis is already the representative PE, so he at any point can change where that is deposited. Otherwise, there's no need to keep this conservatorship open, and I filed a petition to terminate this conservatorship and allow Mr. Hollis to serve his wife without the autonomy, or with autonomy and without the oversight of the court.
Thank you. I think this was also adjourned several times looking for an inventory and potentially the accounting that goes along with that. Were you able to resolve those outstanding issues?
Yeah, we were able to, I submitted an inventory. We were able to pull the bank records from the one bank. I cannot tell you if there are other banks out there, but again, that one bank showed that the only action that was occurring was the rep payee payment. And when I spoke with Mr. Hollis the other day, he did mention he is the guardian, and he did notify Ms. Hollis of this hearing and the reason for the petition. So all the parties were notified, and he agreed that there is no need for this conservatorship.
Thank you so much. Any comments, Mr. McFarland?
Your Honor, I believe it's appropriate. It can be a financial drain to continue to have the conservatorship when there aren't sufficient funds. I think the special fiduciary for doing that research.
All right, Mr. Hollis, I know you love to come and see me.
It was hard this morning. I worked out too in a few minutes, rather than a few minutes late.
All right, well, unless you have an objection, I'm going to go ahead and terminate the conservatorship based on the information that I have in front of me, which will eliminate or end the obligation you have to our court in that context.
Thank you.
All right.
I do have one question, Your Honor, and that's of the special fiduciary. How are her fees going to get paid? Has she submitted a bill?
Well, hopefully Mr. Hollis was able to take care of that, but Ms. Meinhardt, is that an issue for you?
I had assumed this was a pro bono case, and seeing the funds that are available to Ms. Hollis, I'm fine with that arrangement.
Well, thank you. We really appreciate your efforts on that. And I know Mr. Hollis does as well.
Thank you.
I will note the same, Your Honor. There be no future billings for me since she's determined there's no income, just to let Mr. Hollis know.
Okay, all right, Mr. Hollis, I'm gonna sign the order terminating your obligations as a conservator. If you'd like a copy of this today, you can wait across the hall or they'll mail it to you, whatever you prefer.
They mail it to me.
All right, well, we're all set then.
Okay, thanks.
You're welcome.
Yeah.
Thank you.
Thank you, Your Honor.
Thank you.
This is in the matter of the estate of Sharon Nichols, file 53084.
All right, court's been asked to open up this estate. May I have the names of our participants, please?
Good morning, Your Honor. Yes, my name is Lori Miller, and I am representing the petitioner, Cynthia Nagley, who is also here by Zoom.
All right, it's a little bit muffled on our end. I'm sure it's our acoustics, not yours, but I just want to verify. You're Lori Miller, Lorriemiller.
Yes,
And then your client is Ms. Cynthia, is it Nagel?
I believe she says it Nagley, but
But the next case raises an entirely different problem. Sharon Nichols passed away years earlier, leaving behind only a satisfied land contract without a completed deed.
maybe she would like to say that for the court because I could be pronouncing it incorrectly.
Good morning, Your Honor. Yes, my name is Cynthia Nagley.
Well, good morning, Ms. Nagel. Thank you.
Good morning.
Ms. Miller.
Thank you, Your Honor. Your Honor, we're here on a petition to open an estate for Sharon L. Nichols. Excuse me. Ms. Nichols passed away on February 23rd, 2017. She had only one asset that we know of, and that is a land contract with Miss Nagley. The land contract was from 2012, and it had been satisfied, but there was never a deed done. So at this point, really, Miss Nagley is filing as a creditor because she's not an heir. We have tried to contact the two children that we believe are living, as far as I can tell, but we have not been able to contact them. We have done quite a bit of research. Miss Nagley, Your Honor, can you hear me okay?
It's fading in and out. I think it has to do with your microphone. I'm catching what you're saying, but it's
Okay, I'm going to just lean
taking
in
a little
bit,
while.
and hopefully the microphone will pick me up a little bit better. I apologize for that. We did try to contact the two children. Their names are Rick Nichols and Sabrina Thomas. Miss Nagley did quite a bit of work before coming to me. She did quite a bit of searching on People Search, trying to find these two. She went to a house for each of them that looked like the most recent. Left notes on the door. She received no response. She called a number of numbers trying to reach them with no response. Once I took the case, I did a Lexis search for those people and came up with the same addresses. We sent letters to them with notice, but received no response, and the letters came back for both of those children. So we did publish notice for them and any other heirs on February 11th, 2014 regarding this hearing. The mail notice was mailed on November 30th, but it came back. So at this point, we've really, I should add, there is no spouse. He passed away before Miss Nichols. He passed in 2014. So at this point, we've really done what we could to reach out and try to contact heirs. I don't believe there would be any objection anyway, as the land contract has been satisfied. But of course, we need to let them know if we can. So at this point, we've given notice, and we would ask that the court would appoint Miss Nagley as the personal representative so that she can continue this estate and take care of the deed regarding the real property for which she has the satisfied land contract.
Was there a document filed at the Register of Deeds indicating that the land contract was satisfied?
No, Your Honor, there was a memorandum filed of the land contract. But there was never anything with the Register of Deeds. The way this contract came about, and my client can testify to this if the court would like, but the way it came about was that Miss Nichols owed a significant amount in back taxes for the property. I believe she inherited it from her mother, is what the deeds show at the register. And so there was a significant amount owed. She sold it to Miss Nagley on land contract with that amount being the amount that had to be paid. So that has been paid some years ago, the taxes that were owed. But unfortunately, a deed was just never done at that point.
Do you have information to show me that the land contract has been satisfied?
I do, Your Honor. I actually emailed it this morning. I have the tax, excuse me, the statement from the, we have a statement from the
County assessor.
county assessor, thank you, just showing that the taxes for all those years have been paid. It's now, there are a few, she is still behind on the current taxes, but all of those back taxes from 2012 and previous are paid.
Do you have any, okay, so the long and the short of it is, as a policy, I don't allow a creditor to be a personal representative of an estate. A lot of times, you may have seen Ms. Meinhardt on the screen, a lot of times she'll step in, appointed as a special administrator, or a public administrator, I'm sorry, and effectuate what needs to be done to avoid that appearance of impropriety or any question that I may have, because clearly I'm on the bench, right? I can't go out and do all that investigation. So it's far and away preferable, in my opinion, to have a third party person to do that and to render me an opinion on that. So what I'd like to do, if it's all right with you, is appoint the public administrator and ask you to reach out to Ms. Meinhardt to provide her all that information so that she can assist you in accomplishing your goals in getting that transfer. It does appear that everything else in the file is satisfactory as far as notice, publication, notice to interested parties as best as possible. And I clearly understand the problem, but that's what I would offer to you is the opportunity to have the public administrator appointed, but you'll have to, and I think you'll end up having to contact Ms. Meinhardt to see if she'd be willing to do that.
Okay, I'm happy to do that, Your Honor. If she's not able, would the court have a backup plan?
Well, let's cross that bridge when we come to it. I would be open to, a different suggestion from you or your client as well, if need be. We have some local attorneys I know that would step in once in a while. So I would invite you to sort of explore some of those options as well.
Your Honor. Your Honor,
Yes.
may I say something? Yes, I was wondering, can my attorney do this?
Unfortunately, because she represents you, that also has the inherent conflict.
Okay, what about a notary?
Well, my general practice is to indicate the public administrator, which is sort of a position that the state allows for situations like this. But because we're such a small county, basically we end up.
The hearing concludes with the judge approving the opening of Sharon Nichols' estate while directing attorneys to coordinate with a public administrator before any property transfer occurs.
Just asking Ms. Meinhardt to sort of do that. She's been approved by the state for situations like this, so we got her name from the state in that context.
Right, but I mean, if she can't do it, I'm looking for other avenues.
Well, why don't you take that question up with Ms. Meinhardt?
Okay. All right, thank you.
Thank you, Your Honor.
All right, as far as the estate itself goes, we're happy to grant a request to open that estate to accomplish those purposes, and I'll just simply indicate the public administrator in that particular line, and then we can go from there as necessary.
Thank you, Your Honor. Does the court have Ms. Meinhardt's information, or would I get that from the clerk?
You'll be able to get that from the clerk's office. Yes.
Okay, thank you so much.
You're welcome. All right, the rest of the findings that I haven't already made, it should include that Ms. Sharon Nichols, there is provided information that she was a resident in Monterey County making venue proper in this court, and that she passed away intestate. Given the circumstances, I also find that supervised administration is not necessary, but I will grant the request for a personal representative in a way that isn't as exactly requested, and go ahead and indicate that that should be our public administrator. Otherwise, the petition is granted, the decedent passed away intestate, and the determination of heirs is also contained in the order. I will not require the public administrator to serve with bond, given the circumstances. And as soon as we know whether or not Ms. Meinhardt's willing to take that, I'll go ahead and issue those letters of authority. Any questions?
No questions. Thank you, Your Honor.
Thank
No,
you.
thank you.
That's all for today.
Thank you.
Thank you.
Paternal grandmother, and they are all grateful for the services that got Ashley this far. Not, I try to be culturally competent, meaning they have a grandma at home who does daycare all the time, and I would prefer him out in preschool because more eyes on him and more engagement, more education.
Your Honor, I think we've lost Butler.
I terminated her video feed because
sorry.
her signal was so bad that I was worried that we would lose her.
Thank you.
And also it was giving me some trouble in letting me mute her since we did have some noise coming, but she's here. Sorry, Ms. Heiss.
So they do an at-home daycare when I'd like him to have challenge and nurture and all those lessons at school, but he has done some things like potty trained at home. The car is broken at home and they DoorDash for income. So a lot of times we require parents to be independent financially in housing and in employment. In this case, I believe that because mother has addressed her mental health, I think it's reasonable for us to consider that she is in some sense dependent on Jackson's dad and his mom. And I think that's a normal environment, and she is dependent on them, so she does succeed in that environment. And I don't think that we should wait for her to be independent to say that the risk is eliminated and the jurisdiction should be released. In this case, I think that's appropriate. All of his needs are being met there in the home with the extended family. Thanks.
Thank you. Ms. Thomas.
Thank you, Your Honor. If Ms. McVeigh can be sworn in, please.
Ms. McVeigh, come on up to our witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Ms. Thomas.
Thank you. Ms. McVeigh, you provided a court report for today's hearing, and are there any updates or modifications that need to be made to the report or any of the attachments that are included?
The only update I would have is the car is broken down currently, but with the assistance of Community Action Agency and Work First, we're going to work on getting that car repair done. I know it was in progress. Ms. Molloy was working with those agencies to get the car repair paid for. So pretty soon they will be able to go back to work.
Great, thank you for that. And during this review period, how would you summarize mom's level of compliance with and benefit from her case service plan?
I would say that she's done everything that's been asked of her. She's benefited from, she got herself into individual counseling, which was something that she hadn't done before. And she's doing it through CMH, and she has a really good relationship with her CMH therapist and case manager, and she's been doing really well.
And during this review period, there was also an opportunity for Ms. Brene Moore to observe some parenting time to ensure that there were adequate parenting skills. And it seems like at this point in time, mom is doing well unsupervised. Is that correct?
Yes.
You also heard Ms. Heiss's report and the recommendation, or at least exploring the idea of case closure. Do you have an opinion on that?
I think it would be appropriate at this time. Ms. Malloy has completed everything we've asked her to do. My only concern is the income. There were some shut off notices in the home, but they were able to get that taken care of through NDHHS funds, through state emergency relief funds, so they don't have shut off notices anymore. And hopefully within the next couple of days, the car repair is going to be completed so they can go back to work.
And if we were to release jurisdiction, there's still an opportunity for ongoing case management or ongoing case service stuff. Is that correct?
No, there's not. If the court closes, we need to close.
Okay. And would that terminate any of the services that the family is participating in and benefiting from?
No, actually, all of her services are through CMH. She's participating in case management and counseling through CMH. The Work First program and the Community Action Agency is outside of our agency. All of the services that she's benefited from and participated in that we can provide have been completed.
And I know that there was an outstanding issue regarding the paternity or determining the legal paternity for the child. You are aware that with my office, we had submitted some inquiries to the state of Texas, correct?
Yes.
Watch what happens next. Every attorney agrees the case appears ready for closure. The department believes the goals have been achieved.
And back in March, we received a notice back from the state of Texas indicating that there was no paternity claim in their records, correct?
Correct.
And you don't have a copy of the birth certificate from Texas, is that correct?
No, I do not.
And to the best of your knowledge, do you believe, or to the best of your knowledge, the individual that we've referred to as dad and mom, do they agree that Mr. Kotke is the legal father or the biological father?
Both, yes. Legal and biological father. They've been looking for their copy of their birth certificate. I've been having trouble getting a copy from Texas. It's been really difficult to work with them. But Mr. Kotke was looking for his copy, and Miss Malloy, I just saw her yesterday, and she was gonna continue to look for it. So we've been working on it.
Okay. And to the best of your knowledge, have either parent experienced any difficulties in obtaining services for the child because of the paternity issue?
No. He's receiving speech services now, so that's another improvement I wanted to highlight on, that they did follow through on his speech services.
Great. Is there anything else that you'd like to bring to the court's attention?
No.
Thank you. Your Honor, at this time, I'd move to admit the court report and the attachments.
No objection.
I have no objection.
Thank you. They are received. Questions, Mr. McFarland?
Just one, well, two. You're asking if you agree that this case should be closed today. Is that your position?
Yes.
Would the car continue to be finished if it were closed today?
Yes, that's through Michigan Works.
Okay.
That's who's helping her with that. That's a completely separate entity from us, so.
Nothing further?
Ms. Heist?
During the pendency of the case, is it accurate that mother applied for Social Security disability?
Yes.
And has she had a response?
Not yet. She got denied and then she had to appeal it.
And has she followed through with that appeal?
I believe so, yes.
Thank you. Nothing further.
Ms. McVeigh, did the parents, and I'm sorry if you said this already, but did she get the child enrolled in the Head Start program?
No, she did not do that.
Okay.
The positive is before he could not be enrolled in that because he was not potty trained, and he is potty trained now, so.
Okay. Very good. And have you checked in with her caseworker from CMH?
Yes.
And does he indicate that she is cooperating successfully with her
Yes,
services?
there's a note attached within the documents where he says how great she's doing, so.
Okay, yeah, I was just looking at the monthly reports on the parent aid services. So I hadn't quite made it there yet, but so I have through August there, and it looks like they've met a couple of goals with Pauline, but the Head Start one was one that doesn't look like it was finished. Are there any other outstanding goals that?
No.
Okay. All right, any redirect? Any other witnesses? Ms. Thomas?
No, Your Honor.
All right, Mr. McFarland?
Ms. Malloy, do you wish to testify today? Or are you satisfied with the recommendation?
Oh, she is muted. Let me give her an invitation to unmute.
I'm pretty satisfied.
Okay, is there anything, if you wish to say something, we'll square you in. Do you wish to contribute anything?
The only thing is with the Head
Hey,
Start.
hang on,
they sent me
hang on. If you're gonna contribute, let me have you sworn in, okay?
Deputy Ames?
I can't see you, so can you please let me know when you've raised your right hand so I can swear you in, please?
Yes, sir, I have it raised.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Ashley, what were you going to say now?
So with the Head Start, a great readiness, I called them and they sent me an application in the mail, and I sent the application back in through the mail, so I should be getting a call from them.
But nobody expected what came next. Despite all the praise, the judge refuses to close the case immediately. He explains that the original danger involved untreated mental health issues.
But we were going through great readiness.
Thank you. Okay. I have no further questions. Let me see if any of the other two attorneys have questions.
I have none.
And I have none, Your Honor.
All right, thank you. Anyone else you'd like us to hear from, Mr. McFarland?
No, thank you.
Ms. Heiss?
No witnesses today.
Very good. Any comments in closing?
Thank you, Your Honor. I think that this is, as Ms. Heiss put in her report, one of the times where we do have a parent who addressed the conditions that caused the child to come under this court's jurisdiction. And at this time, the services that she is participating in and benefiting from are coming from CMH or her own initiative, I suppose. And it sounds like the issue for the Great Start Readiness Program is pending through the application. And as it relates to the paternity, that would be my only reservation on this matter. I don't think that there's an issue as to the parents believing Mr. Kaki is the father, but rather that ensuring we have the proper documentation for that. And we have been working on that, and it's just been pretty hard to do with Texas. So other than that, we would request that the case be closed. Thank you.
Mr. McFarland?
I really don't think the parent issue needs to be resolved to close the case, Your Honor. If we were to find the family today, I don't think we'd be involved at all. All the goals have been met, and I think we need to give kudos to Mom because she's really stepped up to the plate. It's not every day. It's very seldom that we get a case like this. This and adoptions make our job worth it. So.
Ms. Heiss?
I agree. Nothing further. Thank you.
All right. Well, I certainly find that everyone has met their obligations in this case, and I appreciate also the efforts of the mother in this file, but I'm not going to relinquish jurisdiction. And that is because the case arose as a result of Ms. Malloy's failure to take into account the seriousness of her mental health issues. And Ms. Renee Moore has also noted that she doesn't need supervised visitation as long as she is adhering to her mental health treatment plan. But on the flip side of that, it also indicates that if she were to decide she doesn't need to continue to adhere to her mental health treatment plan, and we all know and understand that CMH services are completely voluntary, unless, of course, there is a requirement that you continue to participate in outpatient services through a separate mental health court filing, that the court cannot be reassured, in fact, that the child would continue to be safe within her care. So for those reasons, I would like Ms. Malloy to demonstrate, at least for one more review period and through the holidays specifically, that she is able to diligently adhere to her mental health treatment plan. And if the department were to explore another avenue to ensure compliance with her mental health treatment plan in the future, I would be happy to look at that as well as an alternative to the continued supervision of the court in this particular context. I don't want this family back in my court room because Ms. Malloy's decided she doesn't need her medication anymore. That would be a devastating backsliding event that would have a very traumatic impact on this child and on this family. So we'll let Ms. Malloy demonstrate her dedication to that plan moving forward, and the department to explore any other avenues that may assist in providing that continuity for the family moving forward. So I've identified what remains the risk and the reason for continuing jurisdiction and the fact that otherwise everyone is in satisfaction of their obligations. Our final review will be January 8th at 2:30 p.m.
Yes.
Good morning.
Give a verbal report when the court wishes.
Go ahead.
Thank you. Your Honor, I was able to have a pleasant conversation today with Lori. She was recently transferred from a psychiatric unit to this facility. She seems to be in good spirits with me. Doesn't appear to recognize her medical issues, but she was very agreeable to her daughter, helping her with medical and housing decisions, and her brother making financial decisions. As far as assets, she owns a house, a vehicle. She's a co-owner with her brother. I think it's about 40 acres of a farmland in Riga, Michigan. Substantial value. I was unable to reach out to the petitioner until today. Unfortunately, she dropped her phone in the lake, but I was able to touch base with her. Nothing in her background is objectionable. She did advise me that her ex-husband seemed to have embezzled some money from her mother. And in talking to Randy today, there has been a criminal complaint lodged against him, Your Honor. Speaking to Lori's brother, other than medical bills, he has one small credit card debt, about $1,500 that's in collection, although he has money to pay it, probably about $300,000 to $400,000 in assets when you combine the joint farm that he owns with his sister and his other assets here, Your Honor. Seems as though he's taken a position to help everybody else in need and kind of neglected that. But other than that, there's nothing that he reports in his history that would be a negative as far as finances, other than medical bills.
Now the courtroom focuses on the future. Lori's daughter assures the judge she is fully prepared to make difficult healthcare decisions.
And that one credit card debt, which is somewhat concerning since he probably has the equity to pay that off. Hasn't done so, but other than that, speaking to Lori, she does not wish to have an attorney today. She asked the appropriate question, why do I really need one? Understanding that she was agreeing to what was sought here today. So my recommendation would be to grant the petition, Your Honor.
So I'm reviewing the doctor's report. It indicates Dr. John Evanoff, who is an MD, signed a report 5/24/24, indicates he is a physician. There's no indication that he actually examined Lori. He skipped the line where it says I last examined her on. And the examination indicates long history of poor cognition of health issues leading to decline of medical condition or decision-making. So then there's an indication that that interferes with her ability to receive or evaluate information in the following ways: impaired recognition of condition, I can't read that next word. And something and overall health condition, poor health decision-making, and impaired decision-making. There's no indication of any medications. And there is a final conclusion But Mr. McFarland, do you have any concerns about the fact that there's no official diagnosis here?
Well, I know she was in a psychiatric unit as of yesterday, Your Honor. Our daughter can elaborate on the symptoms, and maybe a little bit of a medical history. I do know now she's in a facility being transferred from the psychiatric center, and her daughter can address the length of time they have sought this and the reasons why. So I think we'd actually need some testimony from the daughter to fill in maybe that portion.
There is, I should say, another affidavit indicating Dr. Evanoff has diagnosed her with dementia/DM, something, has been evicted for behavioral issues. So there is a little bit more information here on the second page.
That would explain my conversation with her, Your Honor.
Okay.
Your Honor.
Would you like to? Yes, Ms. Crowley?
She is actually currently at Divine of Sylvania. She was admitted yesterday and she is on our locked dementia unit. I could provide to Mr. McFarland our face sheet, which would have her diagnosis. Unfortunately, our doctor has not seen her as of yet. So I believe I would not be able to give you like a H&P at this point, but I could try to look through the medical records that were provided from the state hospital to see if there is a diagnosis on there from them.
Dr. Deputy Ames, would you swear in Ms. Diana Crowley for us, please?
Please raise your right hand, Ms. Crowley. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Ms. Crowley. So simply as a follow-up question, are you familiar with Ms. Mosley's, like, where did she come from? You said that she had been recently admitted. Do you know where she was admitted from?
My understanding is, as Mr. McFarland said, is that she was at the state hospital. I would have to pull the admission paperwork that came from them, but I could access that for him or send it to the court.
So, but you are serving her right now for purposes of dementia in the lockdown unit? Can you explain a little bit more about what that entails?
We just got her yesterday afternoon, so I have not even had a chance to meet with her until just this morning when I got this message.
How would someone qualify to reside in where she's at right now?
They have to have a dementia diagnosis at some point in their life, or the referring facility has to provide us with information that she needs dementia care.
Well, but not everyone who needs dementia care has to be in a facility like yours, right?
Correct.
So
there are different stages of the dementia, and currently I did not get a chance to get into her file to find out what actual stage of dementia she is in. I do know we've had a couple behaviors since she has entered the facility, and that is partially why she's on the lockdown unit. I think there's some exit seeking and those types of things.
Could you tell me any more about what you've seen since she's been there?
I personally, like I said, have not seen her until just this morning. I was aware that there was some interactions between her and one of our staff members where she attempted to choke her. There was some exit seeking, running into the doors, some yelling that I was informed of. I did not witness any of those particularly, but it was expressed by the staff to my administrator and then discussed as part of our risk meeting today.
Thank you, I appreciate that. Mr. McFarland, any questions?
No, Your Honor.
Okay, thank you, Ms. Crowley, for those pieces of information.
You're welcome.
Anyone else you think we should hear from Mr. McFarland?
I guess we're trying to get out the door.
Like for me to talk to the petitioner, Your Honor, I would like to talk to her briefly.
Sure. Okay. All right, Ms. Crowley, if you could pass this back.
This is where everything changes. After reviewing medical records, family testimony, and professional observations, the judge concludes there is clear.
To Ms. Mosley, please.
Oh, no, the petitioner.
Oh, I'm sorry. Just
This is
kidding.
the
No,
daughter.
not the ward. Ms. Stacy Edmund. Is that right? Yeah, well, there's
Yes.
two really. All right, Deputy Ames, what did you swear in? Ms. Stacy Edmund, and then also Mr. Gary Holmes.
You Gary, sir?
Yes.
You can sit there, but raise your right hand. Stacy, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes. Yes.
Stacy, can you tell the court, as you told me, what brought your mother to the psychiatric unit at the state and where was she exactly?
So it kind of started back at the end of April, beginning of May. She had an incident where she had fallen and hurt herself. I had been staying with her, helping, with general needs for her because she was, in need of care and some help with things that she wasn't able to manage by herself anymore. But she had fallen, and Gary and I thought that she should seek ER attention to make sure that she was okay because she had hit her head. It was deemed at Flower Hospital at that time that they thought that she cognitive and physical therapy did assessments, thought that she should have a care facility for further care management at that point. She ended up going to a rehabilitation center for like a short-term care. And then they did actually send her to Vibrant Life in Temperance, but she was dismissed from there, I believe, 4 days later because of anger and violent issues that she was having there with staff members and some of the residents there. So they gave her an emergency discharge to Flower Hospital from there, and then after that, she was sent over to UTMC, which was an initial recommendation from Flower Hospital before she had some medical concerns that arose.
What is that UTMC?
UTMC is like that's the University of Toledo Medical Center, and she was sent to the psychiatric unit in that facility, the psychiatric portion of that facility for behavior management. Basically, they wanted to try to find a medication that would help manage and try to manage her moods and behaviors to stabilize that a little bit. As she was, especially at night, she was having some of those behaviors that were concerning behaviors and lash outs. So she was sent there in the hopes of them being able to find some answers for her for that. And then we have arranged for her to go to Divine which is where she was just transferred for there. But that was the reason she was at UTMC, was because of her center in Temperance not being able to handle the behavior and them recommending that this was the next step in her treatment.
Thank you. I have nothing further.
All right, very good.
Your Honor, I can't speak to the behavior of yesterday and what has been put in place this far, if you would like.
Go ahead, Ms. Crowley.
We did talk about sending her back out to psych after she choked one of our staff. And what was actually put into place was a PRN Halidol to help by our medical PA here at the facility in the meantime. So I know there is an intervention in the works to try to help curb those behaviors. And then we are going to do further conversations. I do know medical staff was supposed to reach out to the daughter and let her know that order was obtained. So that's where we stand as far as treatment.
This is where everything changes. After reviewing medical records, family testimony, and professional observations, the judge concludes there is clear
At this particular moment.
Okay, all right, so let's go to Mr. Gary Holmes. Gary, do you feel that you'll be able to manage the finances for your sister, and do you know what that entails?
Yes, I do. One of the main parts of it is our names are on together for the 40-acre farm, and I'm in the process of selling that to cover some of her share for the costs of that.
Bank accounts and like any social security funds or anything else that comes in for her, you'll have to manage that for her as well.
Yes. My name is already on her bank account at Worcester State Bank. She had that put on there about a little over a year ago, I think it was.
Good. All right, Mr. McFarland, I trust you've done your usual investigation as it relates to Mr. Holmes.
Yes, I do have one question. My understanding is that she does not have a durable power of attorney and does not have a patient advocate, which is a medical power of attorney. Is that accurate? As far as you know?
Me?
Yes.
No, she does not have that.
Thank you. That's it.
All right, Ms. Stacy Edmond, are you confident and able to help manage the care decisions for Ms. Lori Mosley?
Yes, I am, and I'm willing to do so, yes.
All right, and do you have enough distance between yourself and your ex-husband or future ex-husband, whatever the status is, that we would not have to be concerned about him interfering with your care making decisions or anything else for that matter?
Yes, he was removed from the home a few months ago. He is no longer part of things outside of his every other weekend custody order with the children, but he does not see them here. So he is not involved in anything with us.
All right, thank you. Any follow-up questions, Mr. McFarland?
No, Your Honor.
Anything else?
I don't know if we need to hear from the investigator for the agency or not, but I indicated to the court what he's reported to me. So.
Okay, very good. All right, did you feel that you needed to share anything today, sir?
Your Honor, I agree with what Mr. McFarland said. I've been talking with Mr. Holmes and Ms. Stacy Edmonds about getting this petition filed, and we've been trying to find placement for Lori. So hopefully this is a good fit, because like you say, they had placement for her previously and behaviors. They sent her back to Flower, and this has been going on. I've had the case since May 21st. But they have been both trying to do what they can do, and placement's been hard because of all the issues. But they have found placement, hopefully, and it's long-term placement. And I believe both of them will look out for the best interest of Ms. Mosley.
Thank you. All right, well, the court finds all interested parties were given notice for purposes of today's hearing. I have reviewed on record already the report of physician or mental health professional, as well as the affidavit that accompanies it that confirms the diagnosis of dementia for Ms. Lori Mosley. I've also listened to the observations of her family members and her recent but very qualified caretaker, Ms. Diana Crowley, to understand that her diagnosis of dementia does present that it impairs her to the extent that she lacks sufficient understanding or capacity to make or communicate informed decisions, and is therefore an incapacitated individual as the law describes it. Her need for that high structure environment, the history of how she arrived to that place with different hospitalizations and the evictions as a result of the behavioral disturbances caused conclusively by her dementia diagnosis does also present clear and convincing evidence that Ms. Lori Mosley is in need of a full guardian rather than allowing for a partial guardianship in any way. She clearly needs someone to manage her finances, to make sure that those finances are being properly applied towards her care, as Mr. Harry Mosley has already said he's in the process of doing. And also she needs some help just making care decisions for herself and making sure that those medical decisions can be made, especially if she is at a point, unfortunately, where she is experiencing some of those major behavioral disturbances that are characterizing her current stage of dementia. So for all those reasons, I am granting.
The hearing concludes with the court granting both the guardianship and conservatorship petitions. Lori's daughter is appointed full guardian to oversee medical decisions, while her brother becomes conservator responsible for managing her finances, ensuring every future decision protects her health, safety, and long-term well-being.